lose a little bit in the video translation.
Okay. Good morning, Judge Wallace. Okay, I think that we're all present and ready to go. Welcome to an oral argument session of the 5th District Court of Appeal. I'm Jay Cohen out of Orange County. Joining me on the panel this morning, we've got Judge Rand Wallace. So it keeps moving. Are you in Orange or Seminole now?
I want to make sure you're paying attention.
You just want to make sure no one can find you. And then we've got Judge Jim Edwards from Seminole County. This morning's 9 o'clock case is V versus V. Am I pronouncing that right?
Yes, sir.
All right. Case number 193450. We are recording this on YouTube, and we have just a rash of YouTube fans, apparently, sometimes getting all the way up to 8 or 9 people viewing at a time. So just keep that in mind during the course of your oral arguments. We'll allow, just as a default, a 5-minute rebuttal for appellant. If you'd like something other than that, just let me know. I'll be glad to accommodate whatever rebuttal time that you would like. So with that, we're ready to proceed. Mr. Rigby.
Good morning, Your Honor. Good morning, Judge Edwards, Judge Wallace. I'm Barry Rigby. I am the attorney for the former husband and appellant. And Judge Cohen, the 5 minutes for rebuttal will be sufficient. I doubt that I need 15 minutes for my initial presentation, depending on how many questions the court has.
No, there's a penalty for not using all of your time.
Very, very good. And because I feel like I've got enough time, I do want to just outline my logistics here. I'm working from my home office. There's nobody present with me. I've got a binder in front of me, and I've got a desktop computer with some of the key documents up as PDFs if something happened where I would need to refer to those. Most likely that will be during the appellee's argument. But
Mr. Rigby, this isn't a bar exam. We don't think you're cheating.
There is something about the panel that's reminiscent of the Board of Bar Examiners panels, though. I feel the vibe. So with all that being said, I really want to simplify what we want to say on behalf of the appellant in oral argument, because the briefs are pretty thorough on both sides. To a large degree, this is going to be similar to so many highly contested divorce cases that make their way up to the court. My client, the obligor on alimony and child support, is contending that the amounts he was ordered to pay are off. We believe that the record shows that there are just some errors on the face of the final judgment that in and of themselves warrant reversal just to get clarified, even if in large part they're accurate. There are some mathematical errors that we contend.
Well, I'm trying to understand, what relief are you seeking?
We're asking that the court reverse, send back for recalculation of child support after it makes a determination of what alimony is appropriate, and alimony arrearage as well after alimony is determined by this court whether it was done properly within
what specific errors are you addressing in terms of the alimony? I understand the mathematical the problem we have with income and with the numbers on that. But I'm trying to get more a broad-based philosophical discussion of what you think was wrong with the alimony.
Perfect. And I think those are the more interesting legal issues that are not quite as routine. The marriage was short-term. Our contention is it should count as a 4-year marriage with the period of temporary support. We want the court to determine whether the amount of alimony in the period of time was appropriate based on the number of years of marriage. But then related to that, the record evidence reflected that we had a couple that relied on incurring debt, even selling off items of personal property to make ends meet during the marriage. And it's just a question, how can the former husband be determined to have an ability to pay once the households are split? When they were both together in the same household, they couldn't make ends meet on their incomes. So from that standpoint, we just don't think that it's an alimony award case. You have before you what you need to
start. The standard of review on that would be an abuse of discretion.
Yes, sir. Yes.
Right. And is it your position that there was no permanent alimony? This was a durational alimony award, correct?
It was a temporary relief, and then 2 years after the final judgment.
So the error was in awarding any alimony at all, according to your position?
Yes. And then there's another component that flows out of this if you don't have any more questions.
Well, are you taking the position that legally the judge could not award durational alimony, or that simply the award wasn't supported by competent substantial evidence?
Taking the position that the court could not award durational alimony in a case with these facts of this duration.
All right, and give me a case site, your best case site for that legal proposition.
That's where I need to refer to my computer over here. I apologize.
You would acknowledge that there are cases out there supporting an award either of bridge the gap or durational alimony in a 4-year marriage.
Absolutely, without question, the bridge the gap. No doubt about it. And that's what we think that the judge really did, yet overlooked the fact that the wife had already moved out, set up her own household. Our sense is,
as a practical matter, does it matter whether the judge called it bridge the gap or called it durational?
We defer to the court on that. Is that an issue that a trial judge needs to clearly delineate? And I think it's an interesting enough issue that the court should, whatever it rules, it's worth speaking to. It's an issue that in a case where the marriage is this short, the questionable lifestyle, our position is not a huge disparity in income. Does it need to be bridge the gap, or can it be durational?
Let me ask this. Do you think that the record is clear that the judge considered the rebuttable presumption against alimony?
The record's not clear in that respect.
Okay, but you're not really claiming that as an error?
No.
Okay.
But the other thing that flows from this, Your Honor, is having made the determination that the former husband should have been paying alimony during this entire period, and he paid some support, the judgment is not accurate. We contend that the court improperly awarded all of its alimony award less some credits, but then awarded child support without factoring alimony in, which we say comes out to a double dip. If he comes out of this with an alimony arrearage and a child support arrearage that doesn't factor in the alimony that's supposed to come from his income, that's a windfall to the former wife.
Or are you suggesting that the trial court did not include alimony in determining the former wife's income? Did you get that?
Yes, I believe that's right. And I believe that the child support guidelines worksheets that were incorporated into the final judgment are reflective of that fact.
And the statute requires that to be done.
Yes. And it should come away from the former husband's income as well.
Right. And that was not done.
No.
And did you prepare a child support worksheet that correctly did that?
We did. We submitted various ones because the income shifted and the time sharing shifted. So there were multiples for the court to look at and consider.
But let me ask you a couple tangential issues involved in the case. Mr. Sudbury claims at various places in his brief that the former husband did not provide the trial judge a transcript of the trial as had been requested by the trial judge. Is that an accurate assertion?
We don't believe it was. Mr. Sudbury was not the trial counsel. And we believe it was provided within the time period that the trial court requested, and certainly it was provided in time for the rehearing that was conducted.
Well, I mean, you were the trial, the counsel below, so you would know.
I believe it was provided within the time that the trial court requested. I don't know that she requested it before the initial final judgment was entered, but once we brought the issues to her attention, she said, I'm going to need the transcript. I can't remember definitely what took place. We got her the transcript. Then we got the ruling after the rehearing, which denied our motion for rehearing.
Now, another issue that you talk about in your brief is the fact that you didn't get a hearing. I think you filed an emergency motion to modify the temporary award that Judge LeBlanc had entered, and Judge Davis had taken the case over at that point in time and made a determination ex parte, it appears, that was not an emergency, so it wasn't going to be set on an emergency basis. Is that correct?
I'm not going to tell you that I know definitely that sequence is correct, because Judge Schreiber was part of the case for a while, and I know she conducted at least one hearing that dealt with some temporary relief issues. But in terms of, was it an error to not grant us the emergency, I understand the policy Ninth Circuit is if it's financial, it's not an emergency.
Right, but my question was, what efforts did you make to get that motion set for a hearing after that?
Well,
that are supported by the record.
What that are supported by the record? Well, there really are not going to be efforts in the record, because that takes place with the behind the scenes jockeying between counsel through email.
Well, all we can do is look at the record. I looked for and did not see a notice of hearing subsequent on your motion for relief from that initial support award.
You're talking about Judge LeBlanc's initial support.
Yes, right.
Well, I'm going to tell you that there were substantial efforts made to try to coordinate that. That's not going to be reflected in the record because it was part of the clash of counsel.
Right. Well, Mr. Rigby, you know that all we can do is look at the record on appeal.
I understand.
Okay. All right. Then go ahead and let me. I know. I'm not going to speak for Mr. Sudbury, but there clearly are a lot of mathematical errors that perhaps are going to need to be clarified here. One of the things that you also raise in your brief is the life insurance issue, and we see this issue all the time. And even though we write on it, we don't seem to be making much of an impression on many of the judges in terms of the findings that are required to be made on before you're going to order life insurance. But it does not appear that you raised the lack of findings in terms of the life insurance issue in your motion for rehearing.
Your Honor, you've known me a long time. I'm going to be straight up on this. I only discovered in researching for another case within the last year the clear law from this court that says the findings of fact issue must be raised in a motion for rehearing.
All right. So the answer to that would be that you didn't raise it in the motion for rehearing.
Did not raise it in the motion for rehearing.
Right. And then you understand at that point, it's discretionary with us as to if we were to remand it, whether we were remanded on that issue as well.
Yes, sir. And I think that our contention really has to be both parties or neither party, just in fairness of overall circumstances.
All right. What other issues would you like to discuss with us this morning?
Your Honor, there's nothing that I need to highlight beyond the briefs. You've inquired of what I thought the more interesting legal issues were that the court should look at and consider an opinion for. I don't know if there's anything that I can add at this point.
Mr. Rigby, were there any tax consequences? I'm sorry, go ahead.
Go ahead. You go ahead.
Were there any tax consequences for the alimony that you wish to address that were raised in the brief?
I don't believe we raised those in a brief.
Okay.
All right. And in terms of the alimony issue, I just want to zero in on your position. Is your position as a matter of law that alimony could not be awarded, or just sticking with it's under these facts, there wasn't substantial competent evidence to support the award of alimony?
It's a longer answer than I'd like to give, but our position is that this is not a durational alimony case. It could have been a bridge the gap alimony case, but the clear record evidence reflected that the former wife had already moved on, set up household, even got the school district, which I think the court knows we have abandoned that issue, such that there was no gap to bridge at that point. The transition had been completed by the time of the final judgment.
Okay, well then, why don't you reserve the rest of your time, and we'll turn it over to Mr. Sudbury.
Very good, thank you.
You're going to have to unmute. It'll be easier for us if you unmute.
Yes, Your Honor. I happen to do that too often. Good morning. May it please the court. My name's Adam Sudbury. Been before the court before. I represent Kelly Veith in this appeal. My office was not trial counsel in this case. We were retained for post-judgment and appellate purposes. And to start out, I would dispute Mr. Rigby's contention that this case is somehow similar to other highly contested divorce cases. That would be the case if in every or most highly contested divorce cases, parties disregarded court orders, did not comply with their support obligations, violated the administrative orders.
Mr. Sudbury, we don't get emotionally involved in these cases. We're looking at the legal issues, and so let's try to stick with the legal issues instead of trying to get us to dislike Mr. Rigby's client. Let's start with the proposition in your brief that they never supplied a transcript to the trial judge.
Your Honor,
Is that what you intended to say?
I'm sorry, Your Honor?
Is that what you intended to say?
No. Well, I believe at the time it is what I intended to say, but I also intend to correct the record here today that the brief, the transcript appears to have been provided, but late.
That's not what you said in your brief.
I understand that.
And when you make those kinds of assertions in a brief, you ought to do that very carefully.
Yes.
So you acknowledge that that statement, and it wasn't just once in your brief, it was on a number of occasions in your brief, that was not true.
That factually untrue. That's correct, Your Honor.
And Mr. Sudbury, isn't it also true that the trial judge expressly stated that he reviewed the transcript? Is that correct?
No, I don't believe that's the case. Unless.
How about record page 14, 874 and 934?
14, 874.
Well, and keep in mind, Mr. Sudbury, when you're given a record site like that, you better be careful what you say. I think it was a she. I think this was Judge Davis at the time, but
I don't recall that in the record, Your Honor. I'm trying to get to that page.
Well, if it's helpful, Mr. Sudbury, I'm voting with Judge Wallace on that question.
That makes it unanimous. Mr. Sudbury, I have kind of a general couple of questions for you. In this particular case, wasn't the trial in February and then the judgment wasn't issued until September?
That's true. The trial was in February and the judgment was not entered until September.
And when the parties brought to the judge's attention that there were inexplicable inconsistencies within the judgment regarding income amounts, expense amounts, and so forth, that the judge agreed that there were inexplicable inconsistencies and that she needed to correct them.
I believe that what the court said at that time was that she needed to see what was in the transcript and what the testimony was at the trial, because she was unable to determine whether or not those inconsistencies came from testimony or whether they came from exhibits.
But Mr. Sudbury, she admitted that she got the numbers wrong. And then she said she couldn't find any notes and her assistant couldn't find any notes. And isn't that when she asked for the transcript?
Your Honor, if you say so, that's not my recollection of reviewing the transcript. Is that she said that she had to see the transcript because she couldn't determine, based upon the transcript, whether or not she got the numbers from exhibits, that they appeared wrong, but that the numbers could have come from testimony and not just the exhibits.
Well, no, I understand that if she had a wrong number consistently. I understood if she said the husband's income was $2,000 a month and it was really $2,500, okay, but it can't be $2,000 a month in paragraph 5 and then $2,200 in paragraph 6. And that's the kind of errors and inconsistencies I'm talking about. Those exist in the final judgment, don't they?
Yes, Your Honor, they do.
And those were brought to the judge's attention. She asked for a copy of the transcript so that she could figure out what the correct numbers ought to be. But instead of figuring out the correct numbers, she denied rehearing, essentially, correct?
She did, but it was after the transcript was provided in violation of her order, more than 30 days after the hearing on rehearing.
So because the transcript was provided late, then everybody just has to live with inconsistent numbers forever? Is that you got a case that says that?
I'm not saying that, Your Honor.
But then you in essence are. I mean, she didn't deny rehearing because she didn't have a transcript, did she?
No, and she doesn't say that in her order either.
The fact that it was late may be inconvenient for everybody and maybe more inconvenient for your client than for the former husband. But regardless of that, she took what, 6-7 months to enter the judgment, was told and agreed that the numbers were inconsistent, was given the transcript, and after acknowledging that the numbers were inconsistent and thus had to be wrong in some respect, she denied rehearing. I mean, you're saying because he was late getting the transcript, too bad for the former husband. I mean, to boil it down, and I just don't understand taking that approach to it.
Your Honor, I think it's hard to argue with that logic. It's true that the numbers are inconsistent. It's also true that the former husband was supposed to provide the transcript within a certain time frame. He was given plenty of opportunity and he didn't. It's also true that it was ultimately provided. So
okay,
there is error in the judgment. I mean, we don't take the position in our brief that there are no errors in the judgment, that there are inconsistent numbers. And
no, but
for example, the alimony.
You do take the position, though, as Judge Edwards said, that, well, listen, it was former husband's fault, and so you ought to affirm. That is the position that you took in your brief. I think we get the picture on it. Let's go to talk about some of the legal issues. Do you agree, as a matter of law, that if you're going to award any type of alimony, that it has to be included in the former wife's income and excluded from the former husband's income in computing child support?
The statute seems to suggest that, Your Honor.
And the trial judge didn't do that, did she?
That is correct.
And do you concede that that is legal error?
We do concede that is legal error, but the court should consider that the overall support award was in fact considered by the trial judge, and that the overall support award during that short time period, the 2 years where the former husband would be paying child support and alimony together, makes the error harmless, because it's the total amount of support during that time period that, unless it clearly violates the former husband's ability to pay, then that total support award, whether or not it's more child support or more alimony, is the thrust of what the judge was trying to accomplish.
Give me your best case to support that proposition.
I'm not aware of an appeal case that says exactly that, Your Honor.
Okay. Now let's talk about the engagement ring. The trial judge gives it to him, but then says, well, everything you got in your possession is yours, everything or on your list is yours, and everything on his list is his, so that he gets, for purposes of equitable distribution, I think it might have been $4,500. I'm not sure if I have the amount of that right. He gets that amount, but he doesn't get the ring. And your position is, well, he never asked for it. I mean, that's your legal argument.
It's not a matter before this court because he hasn't. I mean, that's the judge says he gets the ring, but that's what's in the judgment. She's supposed to give him the ring.
Has she done that?
I'm not aware that she has. I'm not aware that he's ever formally demanded it.
Well, but it was briefed. It's part of this appeal. And on the record that we've got, she's got possession of the ring, and he got, as part of equitable distribution, the value of it. I mean, that can't be right.
But just because she has possession of the ring doesn't mean that that's where it ends, because like people have possession of property that is awarded to one party or the other, and it is her duty to transfer that ring. And if she doesn't do it upon, request, then that's an enforcement matter for later in the case.
Wasn't she ordered to transfer the ring? I mean, that's
Pardon me, Your Honor?
Wasn't she ordered to transfer the ring?
Well, I'm sure that
that's part of the order, and that's kind of the theme that you started out with, is the husband wasn't abiding by rules and orders of the court. This kind of flies in the face of your original argument that you were trying to put before us today. So it's like, I'm ordered to do it, but I'm not going to do it.
I don't think there's any evidence that she has refused to do anything of the sort involving the engagement ring.
I would hazard a guess that if she had given him back the engagement ring, that the appellant wouldn't brief that before us, because if he did, and we learned, and we start talking about that on oral argument, that really wouldn't look very good. I mean, his credibility with this court would suffer dramatically if he makes a representation in a brief that's just not true. Just as your representation that there was no transcript, doesn't help your case.
Well, I understand that, Your Honor, but it's not something. I mean, I'm not in a position to, to tell this court what has happened in regard to that issue post judgment. I think the court should look at what the judgment says, and then, if that ring needs to be transferred, then, Mr. Rigby should send a demand letter and we get it worked out. I mean, that's typically what would happen in that regard, but, he was awarded the ring. And
all right, well, let's talk a little bit about income figures. Is there any way from this record that we can have any clue as to how the judge came to utilization of the figures that the trial judge came to? I mean, they're inconsistent. They're all, they're all over the place. How do we figure out, because the trial judge made no findings as to how she came up with the income figures that she utilized?
Your Honor, the transcript of the trial indicates that there was testimony in regards to the parties' incomes. There were financial affidavits that were considered, and I mean, there was an inconsistency with respect to the former wife's income as well, being stated higher than it actually was. So, I mean, I'll acknowledge that while the judge doesn't go through it step by step, it appears that she was imputed income in addition to, what was testified to as her income at trial. So
well, let's talk a little bit about the alimony then. Do you think that, should this have been a bridge the gap as opposed to a durational alimony? Does it make a difference?
It does make a difference, Your Honor, because bridge the gap is capped at 2 years, and durational alimony could be modified based on exceptional circumstances, before it expires and extended to the maximum term of the marriage. So, I mean, would it be relevant at this point now that we're 2 years beyond the date of the original final judgment? Probably not, because it's there was no motion to modify and extend, but it does make a difference in the event, and certainly under the facts and circumstances of this case, where it's not clear what the former wife's circumstances would be 2 years out from the final judgment. It would certainly make a difference to have for the court to have the ability to extend the alimony out to the 4.5 years if it were warranted and brought to the court's attention by an appropriate motion.
Does there have to be a finding within the final judgment that the judge has considered the fact that there was a rebuttable presumption against the award of alimony?
Your Honor, I believe that a reference to, similar to the parenting factors, a reference to the statute and some specific discussion of the factors that mattered would be sufficient. Being specific as to whether or not there's a presumption, it's listed in the statute, and the trial court did reference the statute, and that the factors were considered by the trial court.
How much time elapsed from the time of separation and Judge LeBlanc's order awarding, effectively, the equivalent of, not only just child support, but support for her? How long did that order remain in place? Or in other words, how long did he make payments under that order before trial? And should that be factored into the fact that it was a 4-year marriage?
Well, Your Honor, the fact that that is a different type of alimony, which is the temporary alimony while the case is pending, I think it's certainly a factor, but it shouldn't, I don't think it should in any way be dispositive, especially when you've got the, trying to find the right word, the rancor and the tug of war type of situation during the divorce proceedings that precludes someone from moving on and moving on with their separate life. So the temporary alimony is one thing, and then once the final judgment is entered, there's the durational alimony. And I think that the court did consider the reasons for the move from the Northeast down to Florida, the impact that had on the former wife, and frankly on the former husband and his earning capacity as well. I think it's within the trial court's discretion to do what she did.
So ultimately, he ends up paying, what is it? It's at least 3 years of alimony on a 4-year marriage.
It's within the court's discretion, especially on these facts.
But you agree that factually that's what occurred. He ended up paying over 3 years of alimony on a 4-year marriage.
Yes, Your Honor.
Okay.
Yeah.
Now certainly she couldn't make the money. I think she was not an au pair, but just looked over children, and that the difference between doing that in Washington D.C. and doing it down here is significant. I don't think there's much conflict about that. Correct?
That's correct, Your Honor. And it wasn't just that; it was her ability to even find work as well once they moved down here. And it took a significant, not to mention their agreement that she wouldn't work at the time.
All right, Judge Edwards, Judge Wallace, any other questions of Mr. Sudbury? All right, Mr. Sudbury, thank you for your presentation, sir.
Thank you, Your Honor.
All right, Mr. Rigby, I gave Mr. Sudbury a little bit of extra time. If you'd like, if you need it, I'll give you an extra half a minute as well.
I really don't have a lot to add. Just to restate in the brief, one of the points that looking at the debt as well, our contention is that the trial court didn't give adequate consideration to the debt that former husband is walking away with, and so the ability to pay is not there. I don't have a lot to add. I'm obviously here for more questions from the court today, but there's nothing Mr. Sudbury said that I'm going to take issue with.
Okay. All right. Well, thank you both for your arguments this morning, and we'll be in recess.
Thank you,
Your Honors.